It is not listed in the court number two.
But I don't think CRLMC, if you have withdrawn, it
Yes.
will come to me. It's only in bail matters that are tied up.
No, court number two is not taking up this matter
No, I think,
because it is a tied up matter. So it may,
see, in a criminal, this is a 482 petition. 482.
482.
482 petition, there is nothing like tied up.
Yes.
You have to go to the assignment. Only bail matters tied up.
Tied up, yes.
The court is not listed any. I have also
Settlements.
mentioned.
That's the problem. Otherwise, I would have taken. You just check it up. There is nothing like
yesterday
tied up
also-
in 482.
No, yesterday I also mentioned for the DR. DR also said that we mentioned in the court also.
No,
Court will say
I'm not sure.
No, no. Assignment to open back.
It will go to the assigned bench. Just verify. Otherwise, I have no
आप
issue.
तोड़ा में तो उठियो।
I have no issue. Otherwise, it can be listed, no problem. But you just verify. Verify from him. If it has to be listed in this court, Monday, Tuesday, anytime you take, no problem. Just verify. Yes.
My lord, item 23, my lord, supplementary. I pray for adjournment, my lord.
23,
My lord. The first time it has come, I will take instruction, my lord.
Yesterday matter.
Night 2 days.
2014. Next week.
1, 2 weeks after. I will take instruction, my lord.
I want to mention, my lord, item 26, my lord, permitted to withdraw, my lord. Today's
20,
6,
26.
My lord, item,
permitted to withdraw, my lord.
Yes, yes.
Item,
Like,
item 18, my lord.
You please file the memo.
yes, my lord. In the code I'll file.
Item 18, my lord, I pray 1 week after.
18, huh?
18. It's 2012 matter. I will
Huh.
take instruction. Bihar Excise, Odisha Bihar Excise Act 47 of A. And I pray, my lord, 1 week after only.
What you 1 week? I will
Because
give
the
you.
file has been, my lord, the file has already been
PO,
lost. I
PO.
just,
Okay, next week, no problem. But
2-year conviction that has been confirmed by the appellate court.
2 years.
2 years conviction.
Let it be how much? I will grant you probation of offense. Think over and come to next week.
Just
Well,
now I verified my
And
lord's
if you-
file.
If you are so sure about in this 47.
Yes, I have just verified my lord's file.
The story is, I'll tell you, the story is there will be only one independent witness, he will not support the prosecution. And two.
No, there is no
official
chemical
witnesses.
examination.
This is the permanent story.
Here, my lord, I have verified my lord's file. No chemical examination was made. That is
All
there.
same. 100% same.
Your lordship.
Think over. Next week.
Or after lunch, my lord, I will verify my lord's file.
Next week I am talking.
Next
Next
Oblige.
week. Next week.
my lord, item,
17, no instruction, my lord. Item
17.
again.
Is it arising out of a conviction?
Yes, yes. 138 matters, my lord, 6 months conviction and 35,000 there. Both the courts, yes, but if the client is not turning up, neither he's availed the bail also. The bail order has been passed by the Supreme Court, it has not been. availed. So,
Right,
no idea.
okay. This is a
I am giving the
petition arising out of judgment of conviction and order of sentence passed by the courts below and confirmed by court below, trial court, confirmed by the appellate court in an offence under section 138 NI Act. Learned counsel for the petitioner submits that despite his best efforts, he could not contact his client and there is no instruction as well. Even the bail granted to the petitioner has not yet been availed by the petitioner. In that view of the matter, the petition is.
I have filed a memo to that extent, my lord.
my lord,
Item number
item,
24, kindly taken up next week on behalf of
24. 1 minute. 24.
2015, my lord.
24. 2015 matter.
that's it, next week.
This is arising out of a conviction
That's
or
it,
what?
On behalf of Mr. B.P. Jajpur.
Convicted. Convicted or some miscellaneous.
We kindly taken up tomorrow.
Tomorrow,
That's it.
Not tomorrow, next week.
next week. My lords, item 9 and 30, both matters have been fixed at 2 p.m. So probably today or at 2 p.m. there will be no court. It will come
Not-
2 weeks
Not
after.
possible 2 weeks.
2 weeks after. 25th, my lords.
Next week is full.
Yes, next week and that the coming week also it's full.
You just check it up how we can adjust it. Huh?
25th will be feasible, my lords.
30 maybe tomorrow.
25th.
Item 30
Yatio.
maybe tomorrow.
25th.
But he has to get ready. I have no issue.
Item?
30.
1-3.
30.
Yes, that's what I. Yes,
Yeah,
that's what I
that-
mentioned. To happen. 2 weeks after we'll
I
fix a date.
just verify from him and he
I will fix a date.
adjust the date
Yes,
because there are a lot of matters next week.
Yes, my lord.
I don't know whether he can prepare or
my lords.
you have to recommend it. Yes.
I am grateful, my lords.
Silent-
Actually-
silent on the-
Right.
sorry, my lord.
Yes, my lords. I will.
I understand that is item 25, my lord. I wrongly said 26.
Aha.
Sorry, my lord.
Nah.
25.
No, 25, he seeks to
Today
withdraw. 26 the listener, 25 one. If I give you a
Permitted with the, yes, with the liberty to file a better application.
25, my lords.
Withdraw the petition.
25.
With the liberty to what?
File a better application, my lord.
You have all liberties.
No, to raise at the time of framing of charge,
Ah,
let that liberty be granted. No problem.
liberty, you have all liberty. Next.
Pardon to mention, Your Lordship, item number 20. Your Lordship, on behalf of my learned senior S.K. Das, praying for
It's a
an
case of
appeal.
2012, my lords. Okay, to each case.
20.
Item 20.
Against conviction.
No.
Against what?
This is a special court matters, my lord. It's not revisable. I will place it for lordship rule 9 minutes.
Discharge.
Yes, my lord.
Is there any stay operating?
No, Your Lordship, the matter is for fresh, the matter is not admitted, Your Lordship.
Eh?
Fresh admission.
The special court matters, my lords.
See, in 2012,
Yes, Your Lordship.
your application for discharge was rejected. Okay?
Yes.
And now we are in 2024.
And then,
I don't know, the trial
the-
might have been concluded by now.
and the revision is not maintainable in your section 9 of the special court act.
That apart, it is, see, nothing survives, right?
Your Lordship will take the instruction, Your Lordship, the matter will be taken up next week.
Monday.
Obliged. 20.
20.
Why can't you
I
take
may be-
instruction immediately? You go and take instruction, there is nothing survives.
12 matter for the first time.
Nothing survives.
Section 9 of that prevention and that special court act provides the order passed by special court is not revisable and appealable, only brief notes, CRL. Is that rule 9 minutes? It says
Time of it. Monday আসো. Monday আসো. देखिए ना.
the rule 9. Rule 9 says minutes.
Have you-
Except no appeal or revision shall lie in any court from any judgment,
I know,
sentence or orders.
I know, see, Asian judgment,
Not Asian.
I-
I'm placing the statute only.
I know, I'll tell you, in Asian judgment is basically that was the question. I had conducted about 80 cases in Prevention of Corruption Act, charge frame, file writ and take a entry order and 80 matters, same issue. Revision is not maintainable.
No, because
Only
this
you can resort to writ and under 480. Anyway, but there is nothing survived in this matter. Shall I dispose it of giving you liberty?
Your Lordship, let it be taken up Monday. Your Lordship.
Letter, see junior counsel unnecessary.
Pardon to mention,
No,
my
that's
lord. Item number 71 of a weekly list can be taken over after lunch.
Every day you seek adjournment. Today the court, today you want that it will be out because you know that court is not going to function after lunch. Every day you are specialist in asking adjournment. Yes, we'll see.
Milords, I may be pardoned. Item number 3, Milords.
Yes,
Item 3, I am seeking for an adjournment, Milords. Can it be possible 1 week after? I'll seek instructions.
what is this matter?
Item 3.
For 10 stimulants. Item 3 minutes.
This is You are challenging order dated 3/11/2022. By this order, what happened? Your application had your application under 370 CRPC.
16 months, 16.
Three, item three,
Item 3.
item three.
Acha, your
564.
your application for discharge has been rejected.
Malad,
Application discharge has been rejected. So therefore, he is aggrieved.
564, item three.
Yeah, my lords, you turn to page, the page 42, my lords. Page 27, sorry. Page 27, my lord, this is an application and this impugn orders by which this is the application rejected
Yes, I have
and
seen.
case was.
Malad, I am just seeking for an adjournment at this moment because I don't have the file, Malad. That is my predicament, Malad. May I pray it can be taken up 1 week after so that I can appraise.
You may not
my
have the
lord.
file, but we have the file. You can't prevent us from reading.
No, Malad, I am just seeking an adjournment so
1
that.
minute, you just want to know what is the case is about. In fact, I tell you, your application for discharge has been rejected long back. And the
Yes,
matter
Malad,
was
I'll
fixed.
seek instruction to that effect. Whether
Since there is
the cause of
there
action
is no
survives.
stay, I think by now charge might have been framed and evidence must be
Malad,
given.
I'll seek instruction,
posted to
therefore I am
December.
praying for some time.
Mr. Pandal, Learned Counsel for the petitioner seeks an adjournment to get instruction in this matter. The petitioner has challenged the order dated 3/11/2022, whereby his application under 239 CRPC seeking discharge has been turned down. And while the impugn order was passed, the court has also fixed the matter for framing of charge on 3/12/2022. Mr. Das, Learned Counsel for the state, submits that since the matter was fixed for charge Vivek in 2022,
In the absence of.
in the absence of any stay operating, in the absence of any stay, absence of stay of the proceeding, the trial might have proceeded substantially. In that view of the matter, nothing survives in the present matter. Mr. Panda seeks adjournment to get instruction in this regard. Leaves the matter Tuesday.
Malad, may I pray 1 week after? Any date subject to 1 week after, Malad.
Friday,
15th or
Friday.
16th of 15th or 16th of July, Malad.
I have given Friday. Yes, next.
12.
Yes.
Malad.
There is no.
Item one.
Malad, item 1, the brief has been transferred long since. We have no instructions per se.
This is
This is the matter regarding the issue of repugnancy and university has disposed of several criminal offenses. I'm giving order. I'm giving. Similar order.
no. The impugn order is 13/2/2020.
Nothing remains to be decided in this matter as your lordships has earlier disposed of similar.
Basing on this common judgment, your lordship, this court of several.
Same.
Sure.
These are the state would actually agree. Okay, Mr. Pandal and counsel for the petitioner submits that he has no instruction matter, no instruction in the matter. Which are submit that this case is covered by the judgment of the court, passing the counsel. Item 2.
Lordship of the petitioner. The relative seeking for an adjournment of the lawsuit because my senior is not unable to come.
Now you have to tell me what is this case. Yesterday only I told you, while coming you must read it. Ask for adjournment, no problem, but you must know what are the facts.
Urgently he has to left for 2.
That's right, but you are holding the brief, you could have read it.
This morning.
But you should have read it, what is the case? At least you should tell where it is against conviction or whatever. You must read it, you are holding the file. I am passing it over, read it, then only I'll adjourn. You must tell me what is the case. Yes, I am just passing it over. Huh? I'll take it up right now, after 5-6 matter. You sit and read it. And tell me at least the facts. These are the opportunity, you know, to know immediately how to address the court. You read it. What is the court? Yes, next.
Item 4. My lord. For cancellation of bail, my lord.
Granted when?
For cancellation is granted bail, my lord. Page 41, if lords will see.
6/9/22 by this court.
4 in anticipated bail application.
6-9.
6/9/22 this honorable court granted bail, my lord, and the trial court granted bail on 21/9/22.
No.
This honorable directed if the petition surrender before the court will
Achha,
approve
okay.
term and condition fixed.
And the bail was granted on 1/9/2022.
My lord.
What are the
The
conditions, sir?
conditions were, that is your lordship, page 41. 41.
Okay. Yes.
That the petitioner shall not threaten or terrorize, ill-treat, or harass the informant and his family members as well as the prosecution witnesses in any manner whatsoever while on bail by virtue of they shall appear before the IO and shall cooperate with the investigation by law. But subsequently, just 2 months after, my lord, they assaulted and threatened, my lord. That's why case has been lost, my lord. If lordship will see annexure 3, my lord.
Who is appearing for
one case and another.
Yes, my lord, I am appearing.
Yes. What is
My lord,
2 cases, 3 cases have been named.
my lord, it is
apparent violation of the condition?
my lord, kindly appreciate. The petitioners have granted bail by the learned trial court pursuant to direction of this honorable. In the meantime, trial has been commenced and substantially progressed. All independent witnesses have been examined. There is no allegation, threat or inducement to the witnesses. There is also no allegation or apprehension that the trial is not fair or the prosecution.
But you are involved in
My lord, that
2 other cases.
my lord, kindly appreciate. There are several cases between the parties. There is land dispute, and there is 144. They have admitted, and the case counter cases against both the parties. And
how many cases you have registered against them?
my lord, in the present case also there a 295 affair, a 296 against them.
If that is the case, why should we cancel your interstate dispute in arising out of bail? Generally, bails are not cancelled.
Well, that is correct, my lord.
Bail, see,
Your lord.
bails are not cancelled. Once bail is granted and trial is progressing.
That I admit, my lord. 4 witnesses have been examined, my lord. In this case,
6
my lord, 4
witnesses have examined. All are the independent witnesses, including the informant.
informant.
The witnesses were threatened.
No, there is no allegation.
Involved in some other case.
My lord.
Some of the accused,
Leave it.
The condition they ଛାଡ଼ନ୍ତୁ ଆଉ control କରିବେନି control କରୁଛନ୍ତି ଅନୁମତ control କରୁଛନ୍ତି
ଇଏ ଗଣ୍ଡଗୋଳ କରିବା ଲୋକ ଆଜ୍ଞା ଆପଣ ଯେତିକି କୋର୍ଟ ଇଞ୍ଜେକ୍ସନ କଲେ ବି ସେ କରିବ It has no meaning. You can't, you, by court order, you can't.
Cancel ପଛେ ଡକର ଗୋଟେ କହିଥିଲା ଆଉ କରିବେନି ସେମିତି ତାକୁ ଇଏ କରିଦେଲେ ଗୋଟେ
No, I will only tell him that he will
Yes,
convey him.
yes,
that
your
only.
lords. Yes,
That's
sir.
all.
Yes, sir. Yes, your lords.
ଲେଖା ଥିଲେ ଭଲ
That these kind of injunction orders has is neither here nor there.
ଖାଲି ଏତିକିରେ ଯଦି ଖଟନ କରିବେ ତାହେଲେ ପୁଲିସ ପ୍ରୋଟେକ୍ସନ
ଘରେ ପଶିକି ବାଡଉଛନ୍ତି ଘରେ ପଶି ବାଡଉଛନ୍ତି ବଳିଆ ଲୋକ ବୋଲି ଘରେ ପଶି ବାଡଉଛନ୍ତି
Let me take
ଗୁଡାଏ ଲୋକ 13 ଜଣ
Lord, fact is that the
Right. The petitioner has petitioner is the informant. You are
It's of the informant.
petitioner is the informant in the FIR number in the informant in GR case number 819 of 2022. The informant in Nimapada PS case number 295 of 2022, corresponding to GR case number so. Okay. Right on. The petition, the opposite party number 2 has been granted bail by the court below, wide order dated 1/9/2000.
21/9.
1/9/2000.
1/9, this honorable court directed to surrender and
21. Okay, 21/9/2020.
9.
And then counsel for opposite party number 2 submits that the trial has substantially progressed fine. At this stage, petitioner submits that after the release of the opposite party, he has committed 2 more crimes. Therefore, apparently, he has violated the bail condition. And he also submits that there is a threat to the petitioner at the instance of the opposite party number 2. I am not inclined to cancel the bail at this stage. However, if the petitioner feels threatened by the opposite party, he may move appropriate application for the court below. If such application is moved, the same shall be considered by the court below and vary the condition of bail imposed against the opposite party.
Added my lord, order dated 31/1/2024, my lord. This honorable court coordinated by directed the IAC to give instruction. Instructions are already received. Complaint the judicial order passed. 31/1/24.
By 31/1/2024.
31/1/24.
24. This court has directed the IAC to submit for this instruction in this matter. Persons to the said order. Mr. Agoda has placed on record the instruction, written instruction. Is it taken on taken? You move application if there is a threat. Yes. Yes. File. Yes. Yes, sir.
Modification of the terms, my lord. The allegation is that I had taken 1.5 crores from the informant.
Modification of which term, sir?
In fact, there is no term, but there is an observation which I think it stare at me, page 12 here also.
Page 12, huh?
1.5 crores is the amount alleged to be cheated, out of which he says that I have paid 50 lakhs. Balance amount of 1 crore is to be paid within 3 months. If not paid, he will move for cancellation of bail. The affidavit has been filed by the informant himself. Amar kichu compromise in that apart. Your lordship knows the trend also that monetary condition and the allegation and everything. This condition. Why I am saying, your lordship, there is no terms in the order itself, but what the London Sessions Court says, the informant pays 12.
But you yourself have agreed.
I have agreed, but
this is not a condition. On the basis of your concession,
your lordship may look at the look at the agreements.
Now just read it. It says you have compromised the matter with the petitioner and has agreed to finalize the amount of 1.5 crores.
That is what
and that he has already received 50 lakhs. You have entered into compromise.
Nice, sir. Your lordship may look at the.
Then you go and tell that court only. I'll give you liberty.
Your lordship may look at page 13.
13?
The page 13.
Okay.
This is, they say, the compromise petition, whereas it is only signed by the informant.
How would I know? This was, you have to go to that court only.
I am the informant in this case. There is no signature of mine is appearing here. Then next page also, my lord, compromise petition in shape of affidavit filed by the informant. Everything he says, and in the
See, the problem is while they get for bail, you manufacture some document, you say something, out of desperation, you indulge in all these things, got the bail, and now you are saying that I have not done this, I have not done that.
Let's look at the order.
Then what I can do is I'll ignore this compromise and cancel the bail. Because on the basis of the impression given to the court that you have compromised, bail is granted. Today you can't say, turn up and say that there is no compromise. Then it has to be heard afresh. Minus that compromise part, the trial court has to apply the mind and whether you are entitled to bail or not, that will be decided.
That is their sole prayer, my lord. Can see
That's
page
the
4,
only
my lord.
difficulty.
Page 4, my lord. Prayer person.
You take liberty, sir. You go and tell the trial court that this recording of the fact is wrong, which is hurting me. You can tell that.
The prayer
Can it
modify the order to 6
May lordship call it next week or week thereafter?
So ask an adjournment, but ideal thing would be,
I think
see,
also.
ultimately what you are saying is the fact which has been recorded, wrong, right, whatever, is erroneous. So therefore, I will give you liberty.
That is one part of it.
You go and tell that court that, see, these facts are wrong. You please modify it. And after these facts are taken out of the record, whether you are entitled to bail or not, the court will look into it.
Let him consider. So I'll come back to your order. On 11.
Next.
On 11th,
yes.
Item 6.
Why don't you consider it? This is a better idea. Instead of
I think so.
I will give that liberty. You go and move appropriately.
Associate is already
Item 6.
May I please, Joseph? Here, my lord, I am praying for modification of condition, my lord.
Which condition?
My lord, we can see annexure 2, page 14. My lord, this case is arising out of complaint case, my lord. And thereafter, the learned court will grant bail to the present.
Which condition you are?
My lord, condition number 3, my lord. Page 14.
He shall appear before the court in his date of posting.
Put up when bail bond, that is punished, my lord.
You have to appear.
Well, I am appearing since 2017, my lord. This case is arranging a complaint case, my lord. One thing, my lord, is now the present prisoner working in a private company at Bihar, Bodhgaya, my lord. It is very difficult in his part to appear each and every date, my lord.
You have to move application there under because of this condition, neither 205 you can move, 307 also you can't move.
Yes. Only, my lord.
Yes, Mr. Ragada. This blank condition.
I don't know when required that. To that extent.
Because see, his statutory right to move application under 205 and 317, whatever, is taken away.
Yes,
by the
I don't know when required.
by the present petition, petitioner is seeking modification of the condition number 3 imposed by the court below while enlarging him on bail. The condition number 3 reads as under: he shall appear before the court in his date of posting. The present case is arising out of a complaint filed under which provision?
Complaint case, my lord.
Complaint case. Complaint case. Complaint case. So, complaint case. The complaint case. The matter,
all the offences trial
matter is pending before the court, trial court, since 2017. And the petitioner has been appearing before the court on his date of posting, and he submits that in view of because of the said condition, his statutory right to statutory right under section 205 CRPC and 317 CRPC is taken away. In that view of the matter, the bail condition is modified. As and when the petitioner seek exemption, he can move application before the court. If such application is moved, the same shall be considered on its own merits.
Hon'Ble.
Yes.
Item 7.
Yes, sir.
Dismissed for prosecution. Now this application to restore the case.
It was
In
dismissed.
fact, I have removed certified copy not filed. I have filed it.
No, this Where it was dismissed in default what?
My lord, for non-prosecution, nobody appears therefore, your lordship.
Where is that order, sir?
My lord, I have annexed it in
page 8, my lord. So, 14/5/2024.
Why you have not appeared?
missed the list.
Okay, please follow. Will you give 500 rupees to the bar?
Your lordship, the young counsel's case for these cases.
Simply for the reasons stated in the application for restoration, the order dated 14/5/2024 is recalled, and the case is restored to its original file. And tell me what is the merit? Do you have any case on merit?
Can it be next week?
Go to assembly. Once the restaurant, go to assembly.
It is not assembly bench of this.
Oh, this is what is this? Restoration could have been also considered by
No,
the
my lord.
By your
No,
since
our
this
towards
was
the
by
convention is who are-
restore to file, least before appropriate bench,
But
assigned bench.
assignment.
Sir.
Item 8.
May I please? My lord, I have filed this application for modification of the bail condition, my lord.
Condition, where is that condition?
My lord, page number 16, your lordship.
16.
My lord.
Okay.
Let the accused petitioner, namely Lukubhumia, be released on bail on his furnishing bail.
Which condition you tell me?
My lord, one surety must be his blood relation, my lord.
Condition number?
The condition number 9, se para lekha hai, para 2 re.
Let the accused so bail furnishing 30,000 with 2 solvent surety.
Out of the 2 surety.
Out of the 2 surety,
one
surety must be his blood relation
of his own area.
You are from which area?
My lord,
Outside area?
no, my lord, local person, Navrampur district, my lord.
Boriguma.
Main Korapur district, Boriguma.
Right now,
No.
the present by way of present petition is seeking variation of the bail condition imposed by the court below, while enlarging from on bail by this order dated 22/12/2023. The petitioner is agreed by the condition that he is required to furnish one surety of his blood relation of his own area. Blood relation of own area. He submits that due to the said condition, are you out on bail?
No, my lord.
And said condition, he could not be released from the custody. In view of mentioned submission, the condition for furnishing 2 sureties out of 2 surety, out of them 1 surety must be his blood relations of his own areas is modified, and the petitioner is directed to furnish 2 sureties of like amount.
My lord, my lord.
Like
Oblige.
this.
Oblige.
Yes. Item 10. This was 9. 9?
9 has been adjourned, my lord. That was specifically fixed to
yes.
2 p.m. My lord, in item 10, noting has come for acceptance of paper book. Your lordship may kindly accept it and paper book may be served.
Except for the copy.
634 of 21 Miller, no order has been passed, granting leave to continue the criminal appeal. And only delay has been condoned.
Code I number
634.
634 allow कर दिया. The sole appellant in the present case has expired on 29/5/2021. Therefore, the wife of the accused has moved the application under section 394(2) CRPC for continuing the seeking leave to this court to continue the appeal. The for the reasons stated in the application, the same is allowed. Petitioner is directed to file a mandate memo for parties.
Necessary correction we made in the
Huh?
first title.
Remanded memo
File.
parties.
That's one.
Consolidate.
Also accepted the paper book.
And paper will accept for you and
Maybe,
submit
sir.
copy to this week.
Great.
There was one Passover.
But this matter can be tagged in the weekly list.
Yeah.
Right? Yes.
Yes. No, she's reading, later reading. Have you read, madam? No. Now you tell me, item number two.
Number two, Your
Yes.
Lordship.
What is this matter?
Lordship, in this matter, the petitioner is challenging the confiscation case where the petitioner's plea was rejected, where a matter of 2 lakhs was confiscated because he was prosecuted under the offense section 13(2), read section 13(1)(e) of the Prevention of Corruption Act, Your Lordship.
Is it in interim order or final confiscation? Interim?
No, fine.
My lord, it has not been confiscated.
No, it,
We have filed a petition for a release of,
the amount, Your Lordship.
man, there is no provision of release, my lordship, as earlier I have already argued the matter. My lordship, and so far as that Renugala case is concerned, 2 contingencies are there, where it will be refunded.
Just give the citation to her so that she can
Yes.
prepare. No, give it to her. You just see your case, you have to read the judgment. As per the judgment, it is not maintaining. Next time you go and read it, I'm accommodating you for next week, but read it and find out because this is not maintaining.
Your Lordship.
That's what is the argument. Okay, next week. But you must read that date.
Your Lordship.
Yes. Okay.
Obliged, Your Lordship.
Item 11.
Yeah.
Take the citation and take out a, yes. Yes.
11 Lordship, the brief is not with me, Lordship, maybe
Brief?
not trace out my office, Lordship.
This is against conviction or what?
No, conviction,
Oh, CC case.
confiscation, interlocutory order against
As I
confiscation.
have gone through it must have been progressed lot of, my lord.
I will dispose of the matter, giving liberty to you to raise all these points there before the authorized officer, because the interim order. See,
Yes,
you are
yes.
challenging, sir, madam, you are challenging the order dated 5/12/2017. Just see interim order. Confiscation proceeding must be going on.
Confiscation
So
proceeding
I-
going on.
So
My
I'm giving you
difficult-
liberty.
Only my difficulty
Also, my
is
lord,
brief is
they
not.
they have filed another criminal appeal where there is a direction of this honorable court to conclude the proceeding by end of this year.
So then,
Then that is no conflict.
Learned counsel for the petitioner seeks to withdraw this petition to raise all these points before the authorized officer in the
Special court.
confiscation proceeding
Confiscation case.
in CC number 5/2011. 5/2011. With this liberty, the petition is disposed. Yes. Yes.
Item 12.
Well, my lord, conviction matter in a vigilance trial.
weekly list ରେ ଆସୁ
Weekly ଲଗେଇବେ।
Trial court record ଟା ଆସିନି ବୋଲି noting ଅଛି।
Trial court record call for the TCR list in the weekly list. TCR ଆସିଯାଉ କରିଦେବା।
My anxiety is for an early hearing.
ଆପଣ ରେଡି ହେଇକି ଆସନ୍ତୁ ମହାରଣା ଏନି ଟାଇମ୍ ରେଡି ଆପଣ କହିଦେବେ ବୋଲେ ମେନସନ କରନ୍ତୁ ଆଇ ୱିଲ୍ ଟେକ୍ ଇଟ୍ ଅପ୍ ଏନି ଟାଇମ୍ ୟୁ ଗେଟ୍ ରେଡି ଇଫ୍ you think that without trial court record also you can ask
Yes,
for
I
no
have.
problem.
I have got the certified copies of the
And
deposition.
then make a photocopy and give it to him so
They
that
didn't.
he will be ready. We will not wait for
Yes.
this thing and proceed.
Any day next week, your lordship may fix.
Next week nahi,
29th ରେ ଆସୁ 29th ରେ ଆସୁ
29th fix at 2 o'clock. Give
Yes.
you have to supply a copy.
Yes, ma'am.
copies and exhibits also.
Yes, yes.
ସବୁଗୁଡା ଦେଇଦିଅନ୍ତୁ so that we will
ଆଜ୍ଞା,
not
sir,
wait.
ଗୋଟେ set ମୁଁ ଦେଇଦେବି।
Proceed. 2 o'clock 29 fixed.
Item 13.
But I think this is similar to item number 1. That repugnance is similar to item number 1, which has been disposed of today.
peer review ना नहीं
Repugnance is.
रिपोर्ट सी जो आइटम 1 तक इनके ऑफिस में ना डेट उड़ा चेंज करेगी सेटिंग ठीक डिस्पोज करता हूं
Item 40.
नॉन एपीएस को
Defect has not taken this matter.
ये सर
14 routine is the defect has not been given since 2014.
no I didn't follow you what
The defect has not been removed.
use mic
Well, item 14,
uh,
defects as a
defects have not been cured huh?
since 2014.
This is regarding what this is conviction
Conviction matter. 447 SI is for 15 days and fine is 500. So as soon as the petitioner counsel is not available.
nobody comes huh defects are pointed out defects pointed out huh? None appear I can dismiss it because on the ground that defect is not cured
Madam?
on the ground that defect is not cured I can dismiss also
Yes, yes, ma'am. Since 2014 it has.
so then not interested they see it was filed into 30th January 2014 thereafter none appears right on the present petition is filed by the petitioner on 30th January 2014 thereafter none appears for the petitioner on 25/8/2015 when the matter was taken up none appeared for the petitioner and the defects pointed out by the registry has also not been cured the present matter is pending not cured the matter was again taken up on 31/3/2016 and direction was issued by this court to cure the defects. However, till date, defects pointed out by the registry has not been cured. Therefore, in that view of the matter, the petition is dismissed.
Item 15.
What is this matter?
Well, this is a conviction. Rigorous imprisonment for 2 years and fine 5,000. Was convicted under section 406 IPC.
Both the courts have this is a revision petition arising out of the judgment of conviction and order of sentence passed by the court trial court and confirmed by the appellate court. Next one, none appears for the petitioner. In the interest of justice, list next week.
Item 16.
Against an order framing charges, my lord, the revision is directed.
Yes, my lords. So I'll seek instructions in the matter. This has come up for the first time. I'll see whether the cause of action survives or not. That's your lord.
Charge has been framed, that is being challenged at page 16.
Framing of charge by order dated 7/9/2022.
Charge has been framed.
Page 16, lords.
Yes, my lords. Page 16 and next year. I have come up against order framing charges.
There is no stay, so trial must be proceeded.
I'll seek instruction, my lords. Your lordship may grant me one opportunity.
An opportunity will be given to him, lords, to raise all those pleas, lords.
I will give you liberty to raise all points before the court below.
Just one instruction. It was coming up yesterday night itself. I could not seek instruction. One opportunity.
The present petition is arising out of an order, arising out of order dated 7/9/2022, whereby charges against the petitioners have been framed for various offences. This matter is pending since 2022. In the absence of any stay of the trial court proceeding, Mr. Das, Mr. Das submits that in the absence of any stay of the trial court proceeding, the trial has already proceeded substantially. Therefore, nothing survives in this matter. Mr. Ponda, and counsel of the petitioners seeks an agreement to get instruction from his client regarding as to whether any cause of action still subsists or not. At least the matter next week. Yes.
Next Friday.
11. Yes.
12.
That's 12th.
Yes.
19.
19. He was 19. I am for the opposite party, Your Lordship. My Lord. There is a revision concurrent finding 138 NI Act conviction done by the magistrate, learned magistrate. It was upheld by learned session judge. Learned session judge. And there is no, absolutely, my Lord, no material for the
Check him out. Check him out.
1,74,000 some odd, and it was awarded only, the London magistrate has awarded 2 lakhs rupees compensation. That has been confirmed also. 1 year imprisonment and
138, the scope of interference is very limited.
Yes, Your
The
Lordship.
only thing is he has to pay you the money.
Yes, Your Lordship.
Dismissal of this petition will lead you nowhere.
Then I am for the opposite. I am for the complainant, my Lord.
That's what I'm saying.
For the petitioner.
For complaint.
I am there for the petitioner, my lords.
Yes.
In Act 19.
Yes.
But this is against an order of confirming judgment, my lords, of the Corporate Code in an NI Act case, my lords. My submission, my lords, here, my lords, is the order of appeal as well as the order of the learned court below is void per se because the complainant has not been examined under 200 of the CRPC. If your lordship will go through the records, and there is insufficiency of notice also with regard to the demand that has been raised, my lords. That are the twofold arguments, my lords, which I put forth.
Yes. That's, yes, what is
My Lord, that is absolutely no ground, my Lord. He is saying that I have filed evidence in shape of affidavit. That is permitted, my Lord, 145, my Lord.
That's permitted.
And
these are, see, sir, these are summary trials, and the procedure adopted by the trial court is perfectly all right.
145 even NI Act permits filing of
Reduction
affidavit.
operates. It is you have issued the check towards a legally recoverable.
My defense is, my lords, it was a security check which was issued, my lords. Firstly, that has not been taken into a consideration.
Have you admitted the signature in the check?
Yes.
That itself, the petition was filed with regards to the and being sent for handwriting expert, which was not considered before the court below.
Check is 1,75,847.
My Lord.
And compensation is 2
lakhs.
2 lakhs.
How much will you pay?
But
Come to the point.
But I have to seek instruction because the matter was.
See, in the revisional jurisdiction, I will not interfere in the concurrent finding. That too in 138 case. Better that you pay the money and finish it up.
But what I would praise, if my learned counsel for the state seeks instruction if the petitioner is dead or alive, because I have not been in touch with the petitioner. If a local inquiry from the Malkangiri district can be ascertained, if the petitioner is alive, then only.
No, see, these are complaint cases. Why should we burden the state unnecessary?
Because the petitioner has not been communicating.
Then I'll simply dismiss it.
Lordship may grant me one chance
and will follow.
Send a letter to the address, my lords. If that is insufficient, your lordship may dispose it of that way.
Because see, these are complaint case. You are the accused in a 138 case. Why should government will be burdened for? It is your petition. You have to tell me.
Lords, I'll just send him a notice.
Shall I simply dismiss saying that you have no instruction?
No, my lords, your lordship may grant me 4 weeks time, my lords. I'll send him a registered post letter, and subject to whatever is the result, your lordship may dispose it off.
No, not 4 weeks. I'm putting it on 12th.
My lords, it will take at least 4 weeks, my lords, for the ready to return, my lords. That is why.
Mr. Ponda, the matter is pending since 2012. It's a
Milords, I
138.
agree. It was sent to Lok
How
Adalat
much
also.
do you want to burden the court like this?
It was sent for Lok Adalat also, Milords.
Then
But that apart, Milords, I have no instruction, so I need
Then
some
I'll
time.
dismiss it.
I
Then I'll
need some
dismiss it.
time to take instruction, Lord.
You
That
take
is what I'm
instruction.
saying.
I don't know, this is a matter arising out of concurrent finding of both the court below in a alleged offense under section 158 NI Act. The present matter is pending since 2012. Mr. Panda seeks adjournment on the ground that he has no instructions regarding the well-being of his client, well-being and whereabout of his client. Since the matter is pending since 2012, one more opportunity. See, this matter was taken up on 2023. See, so many times.
I had also tried to
And
sign.
in 2023, it was taken up twice on
Could not reach,
16/10/2023,
Milords. Could not reach.
and you sought time.
No, Milords,
And
it
on
could not
again
reach them.
28/11/2023, again you sought
Could
time.
not reach.
Though this is 12. And on behalf of the petitioner, adjournment has been sought many times. I'm although not inclined to grant further time, but on the request of Mr. Ponda, 2 more weeks is granted to the petitioner to ascertain the whereabout and well-being of the petitioner. In the event the petitioner would not get the instruction, the matter shall be dealt with in accordance with law, and it is made clear that no further adjournment shall be granted in this matter. Yes. Yes, next.
My appearance may kindly be
Appearance. 21.
obliged.
Item note 21 kindly Passover.
What password today? What is this matter?
It's about, I'm appealing for the particular 2 matters.
You are the complaining.
This one.
Check amount?
Till 2 lakhs 71,000. The lower court has confirmed 3 lakhs amount to pay compensation of 3 lakhs amount, and the same has been conferred by the district.
See, there is very little scope. Very little scope. You pay the money. Check amount.
Kindly to accept.
Shall I send it to mediation? Have you ever tried mediation for settling?
Sorry. Your lordship may send
Monday. See, you just tell you are appearing for somebody. You must convey that I am not inclined to interfere, and if you want to settle, to pay the money. Otherwise, it has to be dismissed. Or otherwise, I will send it to mediation if you can negotiate with it. Because concurrent finding in a 138 matter in the revisional jurisdiction, I will not interfere. Yes. Next. 22.
Lordship, I 134 that case. Last case, Lordship. I 134 the one draft is there. They ask for release of the draft, Lordship. I 134 of 23.
134. Item 20?
21.
I
134.
There is no I of that kind. 22. I think. Are you holding Dasarathi Behra file? Petitioner is Dasarathi Behra.
No, Ayub Khan.
Huh? ଆପଣ କହୁନାହାନ୍ତି
ପୂର୍ବ ମ୍ୟାଟରଟା କହୁଛନ୍ତି ଯେ ସେଥିରେ ଗୋଟେ ଆୟ ଅଛି ଆଉ ସେଇଟା
Previous matter one I is there, Lordship.
which matter you are?
I 258, Lordship. Yeah, I book 258/23. Yes. To get the draft, which is before the registry, Lordship.
Meantime, they have deposited 1 lakh and they have stated that the mode of compromise.
Take amount?
1 lakh rupees.
They have already paid check amount.
No, my lords. Actually, the total amount which is to be paid is was 3 lakhs, my lords. But in the meantime.
What is the check amount?
2,78,000.
1 lakh they have deposited.
Deposit.
But the remaining amount they will be deposited.
Yes, yes.
And then
And I just filed an application for reelection of that.
Release of that amount.
130.
134 of 2020.
Okay, let him come next time. If he gets the rest of the money, I will release at a time.
Yes, sir.
This must be invested in a interest bearing.
Yes,
Must be. Next.
Yes.
I'm putting it Tuesday or whatever. Tuesday. Yes.
22.
Maybe.
Yes, sir.
My lord, some of the petitioner in the meantime died. So.
How many you offering? 7. 11 people.
11 people. So I have to take instruction, my lord. And also my 2014 matter, my lord. The lower court advocate also has no instruction about, well.
This is conviction.
Yes.
Yes, sir. Confirming judgment.
6 months.
1 year.
Offense?
324. 3.
But who we have to see who is alive, who is dead.
ସେଇଟା ନହେଲେ ସେଟା ତ ଶୁଣାଣି ହେଇପାରିବନି ତେଣୁ ଏ ଲଡସି ମେ urgent this matter.
At that time, they were 40 years only.
अरे 40 years old मरिया को मना.
Well, you get the instruction from the client. Otherwise, this case will be. Where age is 60 or more than 70, then it will be there. But here they are 30 years, 31 years. I have to get the instruction that where
the problem in between there was a pandemic also. COVID time. COVID has not seen the age.
Stay तो मरना थी.
तो मरना. That is your lookout, not our.
No, my lord,
Sir, you are saying that to us.
My duty is to look up. But today morning, this is in supplementary. So you will also kindly granted 2 weeks. I will take instruction.
Yes, that you ask.
What
you are saying to me?
Legal counsel for the petitioner, the base that there are as many as 11 petitioners in the matter, and he wants to seek instruction regarding the well-being and whereabout of the petitioners within 2 weeks. Release the matter.
Okay.
26.
May it please your lordship. Your lordship, I am appearing on behalf of Advocate Sibo Sankar Mishra for the petitioner, your lordship.
Yes.
In this, your lordship, the list was uploaded late into the night and I could not trace the file. Your lordship, may kindly grant us an adjournment for a short adjournment so that we can.
You are blaming the court or blaming the registry or what?
No, your lordship, we were not able to trace out the file. That's it. That's all I want to convey, your lordship.
This matter is pending since 2019.
19, your lordship.
This is regarding what?
Your lordship, we don't have the file. Like I joined this chamber like 6 months back, so I am not around 2019 matter, your lordship. Your lordship, allow us a short period of time. We will get to the file and lordship, I will make it out of it. Vigilance matter.
See, you have moved an application for discharge, which has been rejected.
Yes, your lordship.
Okay.
Yes, your lordship.
Seems it is rejected by a very detailed order. Your application for discharge was rejected way back in 6/10/2018.
Your Lordship.
There was no stay by this court. Was there any
Yes, sir.
stay?
Your Lordship, I'm not aware about anything about the text of this case.
So there is nothing survived. Who is appearing?
Your
for
Lordship may
stay?
grant us at least a short time so that we can trace.
Who is appearing? You are appearing for stay.
Item 25 minutes.
This is
26.
26.
My lords.
26.
This is against discharge.
Yes, discharge rejected, my lords, on 27/2/2000.
No, 18.
18, 6/10/2018, my lords, at page 34, my lords.
How many years? About 6 years.
My lords.
Trial might have been concluded by now.
No,
Why this?
I have no
this is
objection if
pending
my learned friends is provided with any leave, my lords, to raise all these grounds taken in this case in the revision before the learned trial courts, my lord.
I don't. The present petition is
Your Lordship.
an order dated 6/10/2018, whereby the application of the petitioner seeking discharge from the discharge has been rejected. He has assailed this assailed the said order dated 6/10/2018 in the present petition, which is pending since 2009. In the absence of any stay of the trial court proceeding, the trial might have been proceeded substantially. At this stage, stay is not there.
In the absence of interim orders.
Was there any interim order?
No, my lords. Subject to correction. Only, my lords, time was granted to me to take to get the chart sheet, my lords. A copy of the chart sheet on 27/2/2002, my lords. You can see that. 27, I was just to produce the chart sheet copies.
In the at this stage, I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage with this resolution. Yes, I have given the liberty to you. Next.
Thank you.
27.
My lord, item 27. On behalf of the conducting counsel, my lord, I pray for some time till Monday. I have to file a judgment.
What is this case?
Application for discharge was rejected.
When?
Rejected on the year 2019. 29/3/2019.
You were
Petitioner
stay
is the
was
wife.
operating.
Yes, ma'am.
Stay was operating.
No stay is there, my lord. No stay is there. Petitioner is the wife. Case was registered against
Whatever, but see, 2019,
in the meantime, husband has died, my lord. So in last occasion, lordship had directed that in the absence of the husband, the main culprit, my lord, how the case will, the wife will prove the case of
what
disproof.
is you say interim order is not there. For interim order pass earlier shall be.
Stay is not there, my lord. We are permitted to take time before the learned trial court.
What is the stage of the trial now?
Charge has been framed, ma'am, as my learned senior said last occasion. Only till Monday, my lord. I'll file the judgment on Monday.
Judgment of what?
Judgment regarding that in the meantime husband has died. So wife is incorporated under 109 IPC, my lord, abatement. So in absence of the main accused, how she will prove the charges and what is the remedy that she can avail, my lord. That is the only thing I have to prove.
Yes.
Let him take time, my lords. I know it's difficult for him to test out the particular adjustments.
Yes.
Small matter is there,
Great.
it can be taken up.
Simply. Yes.
Next.
Next.
28, lordship, petitioner was died against the rejection of the discharge. Highly revision, petitioner already died.
The petitioner submits that petitioner has expired. When? On? Do you have date? Expired.
In fact, this is for framing of charge, my lords.
Expired. The against the order dated 16/3/2019 passed by the Special Judge Vigilance, since the sole petitioner has expired, nothing surviving.
And one thing, my lords, I got the instruction there. I've got the copy of the order dated 17/12/2021, passed by the London Special Judge Vigilance Denkanla, saying that the case against accused Bisikeshwar Naik stands abated. The case against another accused, Devdas, has been abated by order dated Swens of this court. But this, unfortunately, the case is disposed of in view of the death of both the accused persons. May I pass on the court's orders?
Mr. Das hands up the proceeding dated 17/12/2021 before the Special Judge Vigilance Denkanla, who interiorly has passed the following order. So in view of the above, the case against the accused Bisikeshwar Naik stands abated. The case against another accused, Devdas, has already been abated by the order dated 69, dated order number 69, dated 26/12/2017 of this court. For the reasons aforementioned, the case is disposed of in view of the death of both the accused persons. Both the accused persons. Yes.
29.
But on the last of it was directed to government to take instruction about whereabouts of the petition.
Do you have any instruction?
Yes, yes, I have instruction, my lord. Yeah, the prisoner is Alif and he is residing at Puripani PS, District Balangir, my lord.
Then it has to be heard, huh?
Aye.
Right on. Pursuant to the order dated order dated 25/4/2024. Instruction has been
Miller.
who has given that instruction?
Yes, instruction given, my lord, by the IIC Patnagarh PS.
IIC Patnagarh PS has furnished instructions inter alia stating that the petitioner is inter alia stating that the petitioner is alive and residing at which village?
Residing at Puripani PS, at Puripani PS,
Patnagarh.
Larambha.
Therefore, therefore, release the matter for hearing in the weekly list. Weekly weekly list. It is included. Get ready. Yes. Finish.
Well, I have got a small matter if it can be taken up.
Yes, sir. Which one?
71 matter.
Weekly list.
In case of 493 and conviction and he has been sentenced to undergo SI for 1 year to pay a fine of rupees 2,500. Quite covered case, correct? By this honorable.
Who is appealing for the state?
And
Yes. Ready?
victim is Lord 24 years. PW7.
Offense?
493. 493, 417.
Yes.
Initially, my lord, charge was for the offense under section 493, 417, 294, 506. But and 109 also. He has been acquitted from 294, 506, 109, 114 other offenses. And conviction is for offense under 493 and 417. Accepting the entire case of the prosecution, no case is made out. Well, let me see the evidence of PW7
Bajanti Mala Sahu.
71 na item.
As if her statement will be considered as it is, my lord, that the relationship started between the present petitioner and the victim in the year 1999, when she was undergoing coaching class, but after she was blocked in +2 arts. The relationship they continued till 2001. It is alleged.
I'm trying to locate the evidence. Paperbook ଅଛି?
Revision.
The problem is the scanning is outsourced, and the people, those who are scanning the things in the court, they have no knowledge about the procedure and all. Scanning is so bad. Evidence is not to be seen. Evidence is not there. Do you have the copy of?
I have got it.
Do you have extra copy?
Well, let me see this. I will draw Violet's attention.
No, you have to. How will you have to?
I can argue. It is a small case, but one thing, my lord, is to see basic ingredients of. Basic.
Do you have a copy?
No.
Evidence.
Deposition. No, my lord.
Then make a copy.
My lord, take it up tomorrow.
Monday.
Monday.
Tomorrow.
It's in the list. Yeah, so no problem.
Tomorrow it may not be possible. I may be here.
Monday again, Monday night.
Maybe. So that's why I'm saying.
Monday maybe that be holiday. Monday.
Weekly you.
My weekly.
The first day when I sit. Monday, Tuesday when I sit, you please tell me. So I'll take it up.
Milord.
And get a photocopy and I'm going to copy for them.
Another item, my lord, item 30, which was specifically adjourned to today to be taken up. And my lord and friend.
He'll adjust a date and give that. It has to hurt.
We said that 25th.
Whatever date fix you agree with Mr. Rizvi, and no problem. Any mentioning, sir?
179 weekly list. Any day?
Let it be there. Whenever you come, I mention it, I'll take it up.
Well, next week I'll not be there.
No problem. No problem. Whenever you are there, you please come so that I can take it up. No problem.
Okay.
Thank you.
ready over ready PW3 4 पढ़ियो ता देर पुरो रेडी नॉट रेडी आश्चर्य बहुत गोटिए बहुत तो राजा
छाणी तो छोरी मात्र
नहीं गाली परे फेरैबा
आज